You were just listening in to the Derek Chauvin trial. Today, Judge Peter Cahill heard motions from the prosecution and defense. And we want to go right now to our legal analyst, Joe Tamburino, to break down the details you need to know from today's proceedings. If we start at the end here, we know they just wrapped up. 15 of the first 50 jurors have been released for cause. What does that mean exactly?
That means that the defense and the prosecutor got together at some point before today or during today and decided that these number of individuals could not fairly hear this case. When you agree to have someone stricken for cause, that means both sides agree that that person should not be a juror in the case.
And we know that today jury selection was scheduled to begin, but it's since been postponed until tomorrow. The hope is to continue with that process tomorrow at 9 a.m. And for folks just joining us, can you kind of break down how we started today, how we ended up where we are?
Sure. What happened was that earlier today, the first thing this morning, the defense attorney let the court and counsel know, the prosecutor, that he would be appealing the Court of Appeals decision, which stated that third-degree murder should come back into play in this case. And upon hearing that, the Attorney General's office said that they're going to be requesting the court to delay the proceedings. The court said, no, it's not going to do that. So then the Attorney General said, well, then we're going to go to the Court of Appeals and ask for a writ of prohibition, which is a very special request where they say to the Court of Appeals, please stop the trial court from continuing with this trial. And that's what we're waiting on right now. Hopefully we'll hear it by the end of the day, but it might not be till tomorrow morning.
Now, a number of motions were just addressed this afternoon dealing with issues including sequestration of witnesses. What were some of the motions that maybe grabbed your attention in court today, the ones that kind of piqued your ear?
The most interesting one, and I wrote it down, and it was very, very interesting, was motion number 34. Attorney Nelson stated that sometime, it seemed within the last several months, that he and other defense attorneys went to inspect the actual squad in question here. And in the back seat, they found what they thought to be some type of controlled substance, drugs. And then they asked the Attorney General's office to test it. And those items in the back seat, according to this motion, what Mr. Nelson stated, wound up being drugs. This is unbelievable. That is the squad car in question since Mr. Floyd's death. And how that was not from front to back completely analyzed and everything in it tested early on in this case is unbelievable. That the defense attorneys would discover drugs in the squad car. It's shocking.
And another piece of the conversation today, we know that Chauvin's attorney had wanted to include some information, but he couldn't make a compelling case to the judge. Can you break that down a little bit?
Yes, this goes back to that number 34 motion. What the defense attorney said was that he wanted to bring in Mr. Floyd's arrest in May of 2019. He wanted to bring in it specifically under what's called prior act evidence by saying, look, the method of operation, the MO, modus operandi, of how Mr. Floyd behaved in 2019 was the same in 2020. And then he buttressed his argument by saying, look, when the defense attorneys went to go inspect that squad, in fact, there were drugs found in the back. In fact, it looked like a chewed up pill. In fact, that pill supposedly has Mr. Floyd's DNA. So he wanted the judge to revisit that issue. And the judge says, for right now, the May 2019 arrest is not in evidence or will not be admitted, but he might revisit it.
And he also said at that time that one of his concerns was that there was no sign that Derek Chauvin was actually involved in that arrest, correct?
Correct. And this is part of what goes on when you deal with prior act evidence. It's up to the judge as to what prior acts would be admissible, or even if they are technically admissible, should be kept out because of prejudicial reasons. So this is just part of the process that any trial court would do when deciding whether or not to admit prior act evidence.
Another issue that seemed to be a little bit of a sticking point today was the issue of subpoenas and when to release or not release individuals. What do people need to take away from that conversation today?
A few things. First, a subpoena is a court order. You heard Mr. Nelson say that several times, and in fact, that's true. However, number two, not everyone abides by that court order. So the situation becomes sometimes you will subpoena someone and they not show up. Also, lastly, sometimes you will have parties share a witness. For instance, a witness might testify for the state, but the defense also wants to call them as a witness. So their obligation to reappear in court could happen again. That's basically, it was more of a housekeeping type situation and scheduling.
And when it comes to what to call people in the courtroom, that was one of the issues addressed today. How significant is having that kind of conversation as far as the presentation of the actual case to the jury? And how does the decision of what to call someone, not victim or deceased, but as George Floyd is one of the conversations that took place today, how can that decision impact how the case is presented, how it's perceived by the jury, and why those conversations are so important to have now?
Because those pertain to rules of decorum. How should people, meaning the attorneys, act in court? And on this, it seems the defense and the prosecutor, they're all in agreement that they will abide by certain rules as to how to call someone by their last name, Mr., Ms., whatever that may be, and not use certain other terms that may be loaded terms, such as saying before any case is proven, victim, or saying defendant, or saying wrongdoer, or something along those lines. It's basically just rules as to how the attorneys will conduct themselves in court.
And right now, we know that the plan is to go forward tomorrow with jury selection, but that question is still out there as far as the Court of Appeals and that third-degree murder charge. What's the future for that? What are your takeaways here? It seems still forging ahead.
Yes, well, there's a couple of takeaways. Yes, forging ahead, but also these were a lot of motions just to happen minutes before we start this trial. And one would think that many of these motions should have been handled before today, the day that trial starts. In many cases, when you're doing trial management, any motions that could really have an impact on the trial are handled weeks before the start of the jury comes in. But today it seems we're just getting a whole boatload of them right before this jury is supposed to be picked. It's a little unusual.
And I wanted to ask, as far as the quantity of motions, what is typical and how does this compare to anything you might seen in your career in the courtroom?
Well, I'm not surprised by the number of motions in this case, because again, it's the biggest case in Minnesota history, the first one televised. Everyone's watching this. And in murder cases and in many sexual assault cases, you will get a number of motions. So I'm not surprised that there are so many. I'm just a little surprised that this many is being handled right before jury selection.
And as far as the number of witnesses in this case, we did hear the defense say there's 43 to 100 witnesses who saw some, all, or nothing of this incident, and nearly 400 persons on that witness list. What can you tell us as far as the numbers there, or anything striking or stand out to you, or something to be expected with a case of this kind?
That was not to be expected. And as you heard, what the judge said was basically that they need to pare down their lists and get an official list by the time testimony and opening statements start, hopefully later this month. That's an enormous amount of witnesses. And so I would expect that instead of 400 witnesses, it would be greatly pared down before we actually hear opening statements on March 30th or 31st.
And as we prepare for tomorrow, should the jury selection process continue, what are the main things that you're going to be looking for on tomorrow, on day two, well, essentially day one for the jury selection part?
Well, here's the interesting things. Oddly enough, both sides, the prosecution and the defense, need the same type of juror. when it comes down to it. They need a juror who could be open to new things, new evidence. Rather than just simply look at the video from the defense side, they need to be open to police use of force. From the prosecutor side, they need to be open to facts about what actually led to the death of George Floyd. So both sides need jurors who have open minds and could look beyond just the videos.
All right, thank you so much for joining us, our legal expert, Joe Tamburino. Of course, right now we're expecting to hear from George Floyd's sister in just a few minutes. She was inside the courtroom today as the representative for the Floyd family. We plan to carry that live here on CBS in Minnesota as soon as we get that information. And of course, you can keep checking to CBSN and WCCO.